Edwin, where do you put the stress on your last name, on the first or the second syllable? Okay. Yes, that's it. Russian, among others. Well, one time I was with my son, and he asked me to read him a book, and it was in Russian, and it was about fish. And you know, fish have really weird names. And I started, and I was putting the stress in the wrong place. And he turned to me and he said in Russian, "Papa, you really speak terrible Russian." Ну, значит, у нас, в принципе, 3 часа. 3 часа? Да. Значит, может быть, сейчас 2,5 часа, но сказали, что, в принципе, если мы поздно... И, ну, по докладам или по докладчикам, наверное, минут 8-10, чтобы позволить все-таки развивать какое-то обсуждение. Может быть, если будет живое обсуждение, что другие люди... Да. Okay. Ladies and gentlemen, colleagues, I'm going to start our session for today. And if that continues, I'll speak without the microphone. If anyone has trouble hearing, just let me know. If you need those headphone sets, pick one up, please. And I do speak Russian, however, so if there are any questions or anything, feel free to ask questions in either English or Russian. My name is Glenn Collini, and it's a great pleasure and honor for me to chair this roundtable, which, despite the small number of people in the audience, I'm convinced will be the most significant roundtable and the most significant event of our conference this year. I'm a partner of the Salins law firm, and my offices are more or less across the street on Moika. I've been living in St. Petersburg for almost 13 years, and it isn't always as beautiful as it is today, but you can see today that it can be the most beautiful city in the world. So I'd like to start our session today with some discussion of what is pro bono and why pro bono. I'm a New York lawyer, and in New York we actually have what's called an ethical norm. One of our rules of ethics, Rule 6.1, specifies the pro bono obligations of attorneys, and it says that lawyers are strongly encouraged to provide pro bono legal services to benefit poor persons. Every lawyer should aspire to provide at least 20 hours of pro bono legal services each year to poor persons and contribute financially to organizations that provide legal services to poor persons. So this is the obligation. It's a twofold obligation in New York to work pro bono, and in addition to that, to provide financial contributions to organizations assisting the poor in obtaining legal services. I should note that this is not an obligatory rule. This is a rule which is intended, as it says, is not intended to be enforced through disciplinary proceedings. In other words, if you don't work your 20 hours per week, you do not get disbarred, but it's certainly one that is strongly encouraged, so it's something that every lawyer should do. And I believe that most lawyers in New York understand this obligation and at least do it constructively, if not directly. I should also say that for the purposes today, we'll be discussing not only legal services for poor people. We have a slightly broader concept of pro bono legal services. For instance, legal services to charitable organizations which are not particularly aimed at poor people are also pro bono activities. Assistance with a bar association or legal education programs can often be pro bono. And then the question becomes why. I had dinner the other night in Stockholm with an old friend of mine who for many years worked for the Soros Group and now has been working for East Capital, is about to join the Russian Direct Investment Fund as one of their senior vice presidents. And he was very cynical about pro bono and said, well, what do we need this for? And it's just, the whole thing is it's a give-back theory. In other words, give back to society. And I don't find anything wrong with that. And indeed, I think that is the primary philosophical underpinning for pro bono. And recently, on May 2nd, which is Law Day in New York, Chief Judge of the Court of Appeals, Jonathan Lippman, made a presentation, which I'll come back to later in our session, which I think is extremely important. And indeed, if anyone would like to get the full text of his statement, please let me know. I'm happy to send it to you. It's really an incredibly good statement. And he says, and I'll quote this little part, while we enjoy the freedoms guaranteed to us by our Constitution, we cannot take for granted that the continued validity of those freedoms, the very life of those freedoms, depends on the active engagement of each of us. Those who are privileged to call ourselves lawyers have a special duty as the gatekeepers of justice to participate in preserving what we hold so dear. It is the legal profession's commitment to equal justice and to the practice of law as a higher calling that has made service to others an intrinsic part of our legal culture. So that, to me at least, is the key underpinning, the key philosophical basis for pro bono. And of course, there are many other factors, and I'm sure some of them you'll hear about today. Pro bono is important for recruiting young talent, for training talent, for motivating lawyers. But most of all, in my mind, we are the beneficiaries as lawyers of a professional monopoly. We have been privileged to become lawyers, and we have a debt to society, a debt to ensure the improvement in the rule of law and the administration of justice. And nowhere is that more important than in developing countries like Russia. So with that, I'd like to stop for a moment and turn the floor over to Edwin Rekosh. Edwin is the executive director of PLI-NET. He's a professor at Columbia Law School, although I didn't choose him only because he's a professor at my law school. And Edwin has been in the forefront, and PIL-NET have been in the forefront of promoting pro bono more or less throughout the world, and in particular also here in Russia. Actually, let me... Are one of you speaking? Yes, sir. We have proposed a speech. Mr. Wan. Mr. Wan. Nice to meet you. I'm glad you believe it. Why don't you have a seat over here? Мы нашли потерянного спикера. Okay, so I'm going to hand the floor over to Edwin. All of the speakers are going to speak relatively briefly, around, say, 7, 8, maximum 10 minutes. We're a small group, so we really would like to encourage discussion. People are free to move forward, and please, when you do have a question or a comment, introduce yourself. So with a group like this and 3 hours to kill, we may get to know each other. Edwin.
Thank you, Glenn. The acoustics are really bad in this room. Can you all hear me? Should I speak louder than this, or you can hear? You can hear, okay. So I have a PowerPoint. I will go through it very quickly in the interest of getting through to discussion. Hi. Just one final point is that, in my belief, well, I guess the first point to say is that pro bono is universal anyway in its true essence as an ethical kind of moral obligation. Lawyers from centuries gone by have helped out their neighbors and their family members and other people in their own local communities who might not be able to afford their services. That's an age-old ethic. But pro bono, as I'm using it here and has come to be known among many of us here, is a certain kind of pro bono, institutionalized volunteering, not just any old volunteering, institutionalized volunteering, which is very closely tied to the law firm business model as it has developed around the world. And that, I think, in essence, is why these two trends have driven pro bono to spread. Oh, I went the wrong way. Okay. So this is a slide that's meant to, this is really just based on PillNet's experience. These are some of the NGOs that we've worked with around the world. It gives you a sense, again, of the concentration of where PillNet works. Our model of pro bono is to match law firms, service providers, and in-house legal department pro bono providers on the one hand with NGOs on the other. This is a model that we found to be easy to replicate universally. Many countries of the world, the state is looked to as the primary source of legal aid for the poor. So sometimes there is some skepticism about whether lawyers should volunteer legal services for the poor when the state is supposed to have that obligation. However, there's very strong embracing of the idea that at a minimum, law firms should be assisting private initiatives, civil society organizations that don't get legal aid from the state-supported systems and yet produce a lot of social goods and could use legal services to further their aims for the benefit of society. So that's the model that we have developed and have spread around the world. Let's see, I'm really having trouble with this. Technology is not my forte. I see. I'm getting the hang of it now. Got to get that red thing. No? Okay, that's the next slide. So the previous slide showed the NGOs that we work with. This slide shows where the lawyers come from that support those NGOs. And as you can see, that's spread even more widely than the NGOs that we're supporting. And there again, you see the darkest countries are the highest concentration of lawyers. Lighter countries are lower concentrations. Okay, moving on. That's more than I want to say about trends, global trends. Moving on to Russia. We have been working in Russia for some time now, maybe about 8 or 9 years, I think, on various topics. But for the last roughly four or 5 years, we've been trying to develop pro bono practice in Russia. And we have an office in Moscow that runs a clearinghouse. That's essentially a matchmaking mechanism that is a very, very common mechanism. You'll hear other people talk about similar mechanisms. And these are the law firms that are working with us in Russia. We started out, one thing that's interesting to point out is that we started out 3 or 4 or 5 years ago mostly with international law firms. Because I was saying before, the globalization of law practice has been one of the strongest trends driving pro bono. So it was very easy to attract foreign law firms based in Russia to pro bono because they already had policies on it and programs. And so those firms on the right were the early adopters. But what you can see is that over time, in a very short period of time, just several years, there are now more Russian firms involved than foreign firms. And this is a very healthy development in my view. I have to point out that the international list just got one firm smaller because Dewey and LeBoeuf no longer exists. So that slide was written before that happened. Now I'd like to give you a couple of examples. And I'll end on this slide. So before I get to this one you're looking at now, I'll give you a couple of simpler examples. One example of a pro bono project that we've placed is for an organization called Dance for Life, Russian NGO, whose mission is to help young adults with health issues. And it was a Russian law firm, Mayol Legal Services, that provided them with some intellectual property assistance originally, a simple matter of helping with a trademark issue. But they got so engaged that they started to become strategic advisors for the NGO, and they still work with that NGO, helping them to solve policy questions and also to interact with local and federal government. Another example would be Maria's House, which is a small NGO in a rural area in Russia, somewhere near, my pronunciation will not be good, but somewhere near Peroslavl-Zaleski. And it's an organization that works with young adults and adolescents with disabilities. And in that case, the law firm helped set it up, give it basic advice on its governance, its statutes, and so on, and helped it get teaching licenses. And then finally, the last one I'll mention is called the Beauty for Children Charity Foundation. And in that case, a law firm called Olivinsky, another Russian law firm, helped that NGO, which was also in the public health field. And they helped that NGO to get its registered administratively, and they also helped it to work with the government to have the government meet its obligations to provide certain kind of reconstructive surgery operations for its beneficiaries. So those are some small examples. Another kind of example is represented on this slide here. This was a very large in ambition project. It was one thing that's good about pro bono is sometimes you can get law firms and indeed corporations that are usually competing with each other in the marketplace to collaborate when it comes to pro bono. And this is a good example. This was a collaboration of two international firms, White & Case and DLA Piper, and two corporations, Microsoft and Verizon. And together, and with PillNet, they conducted a week-long course in legal ethics, focusing on issues like confidentiality and basic legal ethical issues, as well as anti-corruption and other very socially important topics. And there was a nationwide competition for the best and brightest Russian students across the country who came to Moscow and took the course for a week at Moscow State University. There was a Moscow State University professor involved, and that happened last fall, and it was very successful, and we're now going to be continuing it on a yearly basis and replicating it in other countries around the world. I got my cue, and
yes.
I'm ending on the cue. Thank you very much for your attention.
Okay, thank you, Edwin. I guess just to come back to two of the points one of the points that Edwin made. Of course, one of the issues in pro bono or legal aid is that we want to encourage governments to provide as much assistance as possible, and legal aid should be or pro bono legal services should be a supplement to, rather than a replacement for government support. That's why in the New York ethical norm it says pro bono legal services that meet this goal, in other words, the goal of providing 20 hours minimum of service, are professional services rendered in civil matters and in those criminal matters for which the government is not obliged to provide funds. So, and this is a distinction I think Michael also will come back to, because in certain countries, in Europe in particular, the system of government support is quite developed. One of the things that's been most important throughout the world in the development of particularly recent development of pro bono, and in particular, I think has been perhaps the single most important factor that has led to the interest in Russia in pro bono, is legal education, and in particular the development of so-called clinical legal education programs. Before introducing the next speaker, I'd like to mention, many of you perhaps have already heard this, but again, Judge Lippman on Law Day a few weeks ago introduced an extremely novel development, which is to require graduating law students to demonstrate 50 hours of pro bono work during law school. And this is the first state of the U.S. to make such a requirement. The requirement has not yet been codified. It's not clear to me whether other states will follow it, but certainly it's an interesting, a dramatic development. And I'd like to read you what Judge Lippman wrote about this. He said, "With this step, New York will become the first state in the nation to require pro bono service for admission to the bar. A better way to send the strongest message to those about to enter our profession, assisting in meeting the urgent needs for legal services is a necessary and essential qualification to become a lawyer. With this new initiative, New York will lead the way in stating loudly and clearly that service to others is an indispensable part of our legal training, and that before you can call yourself a lawyer, you must demonstrate in a very tangible way your commitment to the ideals of our great profession." So we're very lucky today to have Yelena Dobrokhotova. Yelena has been a professor at St. Petersburg State University Law Faculty for over 20 years. Her dissertation was on clinical legal services. She developed in 1998 the model for clinical legal services in Russia, and then implemented this model here at our own St. Petersburg State University in St. Petersburg. So I'm very honored to turn over the floor to Yelena Dobrokhotova.
Thank you very much, Glenn. Good afternoon, dear colleagues. I'm very happy that today the Youth Legal Forum has stated as one of the most important problems, which is of interest to the legal profession, they stated that pro bono is one of such topics. And other issues of pro bono legal assistance are also of great importance here. So from the very beginning, to follow up on what Glenn said earlier, I would like to say that our concept that was developed at the St. Petersburg State University is that the clinic should be compulsory for all students of law school. It is important that students realize that they have to be compassionate, they have to be honored to serve other people, that they become professionals and want to promote themselves in this profession because they serve the people. And then competency and quality of legal services that young professionals are able to offer is another aspect that I would like to pay attention to. The legislature in 2011 made a breakthrough. If the federal guarantee system was created in the Russian Federation, the Russian citizens now, in accordance with the constitution, in certain cases that are covered by the federal law, will be able to obtain qualified legal assistance for free. The federal law on free legal assistance that was passed in November 2011, it is the federal law 324. This federal law has created a unique system, and it has become a unique system because on the one hand it takes care of the government sector, but it also covers the issues connected with the non-government sector. The government will take the functions of the coordinator and will set the standards. The government in the system of free legal assistance will bring together professionals, lawyers, officials, notary public, as well as lawyers working for private companies, and those who come from the non-government sector. There are two participants, NGOs and legal clinics that are part of universities. I would like to pay your attention to two particular aspects. Starting 2011, all the existing legal clinics now have a choice. They either, starting 2012, become part of the free legal assistance system under the federal law, and that means that they will have to follow the standards of quality and conditions prescribed by this law, and the Ministry of Justice promised to formalize these quality requirements very soon. I think it is a very good step forward in order to standardize legal assistance in various areas. If, however, legal clinics are not ready to become part of the system, they can work independently, following their own rules on their own risk. And this is what my esteemed colleagues said earlier. They will be able to expand the services they offer. They will be able to provide help and assistance to a broader number of people. And, of course, I hope they will follow the lead and will improve the quality of professional services. There's a Russian saying, what is good cannot be for free, and if it's for free, it cannot be any good. I don't think we should follow this proverb. This should not be true in our case. From the very beginning, when we conceived the idea of the legal clinic, we decided that it is going to focus on quality rather than quantity. We did not want to have 300 clients served within a week. I thought it was the wrong way to do it. Just imagine a doctor says, I will treat 13 pneumonias this week and 15 mumps cases. So what happens if there are other cases? What if there are other diseases? We have to meet the demand. We have to see what is actually happening. I think, and I thought at that time, we have to teach our citizens that whenever they have a problem, whenever they have a specific case, they should appeal to a professional lawyer rather than bandits or some kind of dealers or underhand dealers. And it is quite possible that I am creating a subject for discussion, but let us discuss this. Let us argue over this. And my point here is this. I think before 2012, the legal clinics wanted to make legal assistance accessible to all. And that meant that we wanted to have more people involved in legal clinics. Our clinic is the biggest. We have 500 students who provide services for free as part of our clinic. We have 60 professors involved in this practice. They help the students first as teachers, and then they provide additional support to their students. So before this year, the legal clinics had to focus more on the accessibility of legal assistance, but starting 2012, that's when the new federal law is going to become actual law, there will be a shift of the focus. It will be a shift towards the quality of service. So if our students are not yet qualified lawyers, we will be able to qualify the service as a quality service in some other way, and that will give a student a beacon and understanding of what the quality service is. And that means that we, as clinics, are moving towards a different method and a different place as those who try to offer services pro bono. If there are people who have experience of working as part of legal clinics, I think you will agree with me here. I want to say that a lot of clients come to the clinic because, first and foremost, it is their last hope, because everybody else denied them. Other lawyers said no, and we are the last resort. So if we become part of the free legal assistance system as part of the government system, then we're not going to be the last element in this chain, but we're going to be the first point of call. I would like to say that there will be two main principles, two main areas for development, because a new system makes it possible not only to structure the overall volume of services, but it also helps to streamline the services. And it actually tells you, and that's what the federal law in Russia does, it tells you which legal clinics can do which types of services. So legal students can only now create specific legal documents and offer assistance in certain legal areas. That's what we did before. Our idea was to supplement real lawyers. Obviously, in a situation whereby we would not have lawyers, then this would have been a very good idea. But we have a lot of lawyers. In fact, we have too many lawyers in Russia. And so I believe our idea is not to supplement lawyers, but to cooperate with the real lawyers. We have to structure this cooperation. So my idea is that we have to specialize while cooperating, and everyone will concentrate on their specific area of work and improve the quality. I think the federal law provides such an opportunity to us. And finally, those who find themselves outside the system, for example, the system of pro bono services, and I mean here people who supplement the existing assistance available, possibly a more qualified, a better quality assistance compared to the free assistance provided by the government. We have been cooperating with such entities for a long time because we believe that our ethic principles are the same. We want to become more professional in what we do, and I think we can redirect and refer clients to each other. This is what we do. This is our form of cooperation. And the final point I wanted to make, some organizations that in 1990s started doing some pro bono because they were funded by foreign grant givers, stopped doing this, and they have accumulated some experience which would be a pity to lose. These people now come to St. Petersburg State University to improve their qualifications, and they want to help the clinics. That's why the clinic is part of the university, and 4 times a year we offer such a program for improved qualifications of lawyers, and they help us in the clinic. Thank you very much. I'm very happy if I gave you some food for thought.
If people have questions at this point, feel free to ask them. Yelena is our only, let's call her, academic speaker today. So this would be an appropriate time to ask questions about legal education, about clinical legal programs. And just to start things off, let me ask a question. As a partner of an international law firm, how can we work with the clinical programs in St. Petersburg and Moscow to help you on the one hand, and also for you to help our lawyers learn how to practice in a pro bono context, or in a different context in which they're used to practicing?
As I said, we have a lot in common. We have the same ethical principles, and we strive to offer diverse but very high-quality service to different areas. And you can find different agents in these areas. Yours and ours, there are different partners, and they all know what to do in their specific areas. We have to pool our resources. I think we also need to communicate in order to initiate joint projects. We had a youth legal forum yesterday, and there were several proposals of that kind. Under the Association of Russian Lawyers, we wanted to create a multi-level school which would help those who are part of the legal clinic system. In order to do that, we have to collect information first, and this is where you could help us. Take information, find information about what is needed, what are the growth points everywhere, so that we could understand what's needed, first of all, what is the demand, and also to understand what we can do in order to help everybody. I'm Vladimir Bagayev, clinic.ru portal. I know that in England and in some other foreign countries, some universities provide legal assistance on conditions that are very similar to pro bono. They provide assistance to NGOs, international agents, for example, international organizations such as the UN, and they provide assistance to the UN on a number of legal issues, for example, on collecting information from various legal systems in order to create comparison tables. As far as I understand, the legal clinic at the university, St. Petersburg State University, is a very different type of clinic. You provide assistance to people. Are you planning to provide any other kind of pro bono activities at your clinic? Thank you very much for your question. It is a very direct and constructive and strategically important question. It makes it possible for 20 hours in accordance with the New York legislation. 20 hours, that's how many hours lawyers have to work pro bono. What ethic?
But it specifically says that it is not an obligation. In other words, it's not something that if you don't do it, let's say if you don't respect conflicts of interest, if you violate the rules on advertising, you can be disbarred. But you can't be disbarred for not doing pro bono. Nonetheless, essentially every large law firm encourages pro bono, and indeed there's a competition among law firms for pro bono. Edwin here has shown us a slide with the sort of flip side of how people cooperate together. But even more exciting to me is that law firms are now competing for the top pro bono cases. Which is indeed what you should expect, that these cases are indeed desirable, and they make the law firm more attractive, they enhance the brand of the law firm, and so indeed law firms now, I recently attended the PIL-Net Pro Bono Conference in Berlin last November, and heard Freshfields and Clifford Chance describe how they competed for the Oxfam representation. And this is, to me, a fascinating development and one that I look forward to seeing in other contexts. Have I answered your questions?
And I think then what's also worth mentioning in that context is that many of the large international law firms have their own internal mandatory requirements to complete pro bono hours. For instance, my firm requires 25 hours minimum of pro bono from each associate, and I think all the large international law firms...
Michael, you have to speak into the microphone because the translators can't...
Okay, my apologies. No, I thought what's worth mentioning in that context is that many of the large international law firms now also have their internal mandatory rules for lawyers to complete pro bono. Usually it's not an expectation, it's mandatory. At my firm, it's 25 hours per year. So an associate joining us needs to immediately ensure that he or she finds pro bono work either within the firm or through an organization. And we count pro bono hours towards billable hours, meaning, as you know, billable hours is a major...
Санкции все-таки есть, его не возьмут на работу, иначе.
Exactly. It's a major...
In this case, there is a sanction.
So before we had this mandatory rule, associates were concerned that if they do pro bono work, they would, be somewhat out of the competition for billable work, and that's why at our firm up to 200 hours of pro bono work counts as billable work, and the mandatory requirement is 25 hours.
Good afternoon, colleagues. A short remark concerning the mandatory character of pro bono services. It seems to me that the element of the mandatory rendering of this service can be damaging for the pro bono institute, because this from the point of morale and ethics, it's one matter. But if there is a law according to which pro bono service is to be rendered in 20, 30 hours or 10 hours, there is a risk of lower quality of these services, because people will start thinking just about hours without considering the quality of services rendered. So I can see a risk in that. But after Glenn says that in New York, we're first of all talking about the moral and ethical obligation. Then, of course, there is no question of that.
It's an interesting one, and you know, as already has been mentioned, the same procedures, the same relationship to a project must be observed whether the project is a billable or a non-billable project. The same attention to conflicts of interest, the same attention to supervision of younger lawyers' work to make sure that, and failure to provide quality services on a pro bono basis is still a matter which is in which the client can actually commence a legal action against the law firm for malpractice. So the fact that you don't get paid for work doesn't mean that you can in any case lower your standards. Similarly with insurance, you know, the work is insured, and you have to maintain the same standards. But I'm sorry, maybe you had...
My second question, if I may. What do you think about the law 324 enacted in January this year? What kind of disadvantages do you see in the context of this new law? It's the law on pro bono legal help. So allow me to answer this question very briefly. It's the very first step, and it's a result of political compromises. Any lawyer reading this legislation will see that this law just creates a framework structure, formulates the underlying principles and the range of the entities involved, and distributes the types of services by the actors. Then the Ministry of Justice will have to do a lot of work on setting out which particular fields of regulation are to be regulated, so to speak, on the one hand by the federal legislation, on the other hand by the regional laws, because the focus here is on the regional level. And this is absolutely correct, because democracy should be not at the top level, and even if it is in Moscow at the top level, it should be at the level of municipalities as well. So this level of legal transparency, accessibility, is the matter that we're working on. So I think it's not the proper time to talk about the disadvantages. I would rather say that it's very good, it's very positive that we have the law. I would like to add a few words concerning this new legislation. Well, of course, the adoption of this law was most necessary. It was necessary to systematize the pro bono work, but it seems to me that this legislation should be limited to the subsidized legal aid and should not regulate all other types of pro bono services, because first of all, it is impossible to foresee all types of pro bono legal aid, and it is not really feasible. When we talk about subsidies, about the compensation of some of the costs, it is necessary, but in all other cases it's not needed. And that's an interesting matter indeed. And Pilnet, who drew up its conclusions concerning this law, and they spoke about some of the drawbacks. Some of those comments were considered, and many, unfortunately, have not been taken into consideration. Я думаю, что
I just can't resist to make one small comment. Our Russian staff did do a lot of work with the Ministry of Justice on trying to craft good law, good legal aid law. Not all of our recommendations were taken. One thing that we're still a little critical about is while on the one hand it was very good that the law expanded eligibility to cover a lot more groups, it also restricted the types of cases. So it gave with one hand and took away with another. And another concern that we have is exactly the point Dimitri's making. There's regulation of not just the service providers that receive state funding, but all service providers. And to some extent, they're now more restricted than they were before, for example, in court representation. And just one terminology point is the translation is translating that law as a pro bono law. Perhaps in Russia that makes sense, but I just have to say that internationally, generally speaking, pro bono and legal aid are considered to be two separate things. Pro bono usually is referring to purely voluntary legal services where the lawyer is not paid specifically for that service. They may receive a salary from their law firm, like usual, but they're not paid for the service that they're providing. Whereas in legal aid systems, there's a state subsidy paid to the lawyers who are doing it, and with NGO projects, sometimes the NGO lawyers might be getting paid for the service.
Yeah, the law is somewhat poorly named, and so the literal translation would be the law on free legal services, but it really is a legal aid law. It's a law on subsidies. In any case, let's go back now to the panelists, and our next panelist is Michael Meissner. Michael is a partner, as he mentioned, at the Deckert law firm based in Munich, and is in charge of the Deckert Munich, or maybe all of Deckert. Just the German part of Deckert's pro bono practice. And Michael will help us to understand the approach that Germany has taken, one of the countries which has been in the forefront of state aid to provide legal aid for indigents, but on the other hand has certain restrictions which make it difficult, or have made it in the past difficult, for lawyers to engage in pro bono legal services, and that is in particular the mandatory pricing that is not permitted for a lawyer to price below a certain statutorily established level. So this is quite an interesting problem, I think, and let's hear what we're very glad to have Michael to discuss it.
Thank you very much, Glenn, and obviously also thank you for the forum to invite me here. I'm actually, while in daily life, in my daily practice, being a bank lending partner at Deckert, I'm also the pro bono partner at Deckert for Germany. I'm actually primarily not here on behalf of Deckert, but on behalf of an organization which is called Pro Bono Deutschland. That's the German Pro Bono Association, and that has been established in February 2011. And our chairman, Christian Bunsen of Freshfields, was unfortunately not able to attend, and I replaced him as a board member of Pro Bono Deutschland, the German Pro Bono Association. And I'm going to talk a little bit about why the major Anglo-American law firms and some other large domestic firms in Germany established this organization, and how it fits into the system of legal aid, because what Ed says is absolutely right. It's exactly what we're not doing. We're not replacing or complementing legal aid. We're doing something distinct. You know, pro bono in Germany has been on the rise for quite a while, and we started with pro bono round tables in 2005, and each of the larger firms operating in Germany that already had exposure to pro bono, usually through its overseas offices in the US or the UK, sent representatives to those pro bono tables, and this sort of initially informal format eventually grew into an organization which we now have for a little more than a year, and which really has, the agenda to promote pro bono within Germany, lobbying at the local bar associations, lobbying at legislation at the legislative level, and also really getting the message across that we're not competing with legal aid, and that we're not competing with the rather smaller law firms providing legal aid, because there's still significant misperception about what pro bono is, because legal aid in Germany is essentially a form of state welfare assistance based on various constitutional principles, and is centered around a litigation setting for the poor, either in court or with respect to an administrative proceeding. So the lawyers assuming such legal aid mandates are thus not working pro bono, but they're paid by the state, subject to statutory fee schedules. And for many of the small practitioners or smaller law firms, it's really part of their daily business. And when we started to institutionalize Pro Bono Deutschland, we've gotten some very skeptical reaction from this part of the bar, because they thought we would take away something from them, and that's actually what we're not doing. So what we're really contemplating is to achieve greater recognition and more widespread implementation of the concept of pro bono legal advice among lawyers in private practice. And I should maybe, just to give you an idea how this group evolved, name some of the firms which are members in our associations. There's Elnory, there's Eschers, there's Clifford Chance, there's Debevoise and Plimpton, there's Deckard, my firm, there's DLA Piper, there's Freshfields, there's Hogan Lovells, Latham and Watkins, Linklaters, Mayer Brown, McDermott, Oric, the German firm of Gerg, Reed Smith, Skadden, White and Case, Taylor Wessing, Weil Gottschalk. So, quite a large group of international law firms participating in Pro Bono Deutschland. And as I said, we're really trying to improve the conditions under statutory law to provide pro bono, because honestly, German ethical laws do not provide for this concept. So we're currently still operating in somewhat of an unregulated area, and it's really an Anglo-American concept to have a pro bono practice, to essentially give someone back to the society and the economy for which you function as a legal services provider. So we're doing a lot of lobbying at the federal and local bar level, and our sort of ultimate goal is really to initiate a legislation which will eventually take pro bono out of this unregulated area and really clearly, distinguishes it from legal aid, and essentially, supplementing the legal aid system we have in Germany, which, as I will explain right now, is very limited and doesn't cover pro bono. What's very important to understand about the German Pro Bono Association is what we not do. We as Pro Bono Deutschland itself do not render legal services, and we do not coordinate pro bono activities or solicit pro bono matters for our members. So we're not a clearinghouse. And we actually heavily depend on establishing contacts or work on existing contacts with clearinghouses like PillNet. Obviously, this is an organization our global pro bono chair, Susie Turner, is heavily involved with. Now let me, if I'm too long, Glenn, just cut me short. Just a few sentences about the legal aid system in Germany, because I think this is an area where maybe what's happening in Russia, you may or may not want to get some ideas of how a system is implemented and how pro bono can supplement it, such legal aid system. So, as I said, legal aid is really a state welfare assistance in court and in connection with certain other legal proceedings. And you can claim, if you're poor and you have a legal matter you want to pursue, you need to take legal action at, you can apply for legal aid, and it can relate to numerous areas of law. There's no limitation. It can be a civil law matter, it can be an administrative law matter, it can be criminal law matter, it can be employment law, it can be family law. Obviously, often legal aid centers around social security law and family law. And there's a sort of basic statutory right to legal aid set forth in the German Civil Procedure Code, but this is really sort of only the source of the procedural right, which would apply to many other areas of law. And if you want to apply for legal aid in Germany, there's really two things you need to look at. Number one, there's an objective requirement for legal aid, and that is that legal action or defense has a reasonable probability of success. So that requirement must always be there. Identify local clearinghouses if there are any. We haven't really gotten to the local level yet. I mean, we're doing well on the international cross-border level, which is promoted by organizations like PILNet, or where you had a lot of clearinghouses or NGOs at the European Pro Bono Forum in Berlin last November. So this is working well, but we haven't really gotten to the local level. For instance, the neighborhood in Munich that is facing increasing rents because wealthy people moving in, and there's an initiative forming. How do we get to these people to support their case? And finally, we're really still, we haven't really figured out how do we get to the segment of the legal market that's really looking at us a little skeptically. The solo practitioners, smaller law firms. How do we get them involved? How do we include them in our efforts? So this is a very difficult task. Lessons learned for pro bono in Russia. I don't know if there are any, or if you think there's something comparable or different, or if you would like to ask any questions, happy to answer them. Obviously, if you're interested in receiving my speaker notes for this little speech with the outline, just give me your business card and I'll happily email them to you. Thank you.
Great honor to introduce John Wotton. Is that how you pronounce it, by the way? Wotton. Okay. John is president of the Law Society of England and Wales, one of the most active and highly developed bar associations or law societies. All of us at Salins are members, and John, in addition to that, is an antitrust or competition lawyer and is of counsel to Allen & Overy. We're very glad to have you here in St. Petersburg and that the Prime Minister let you go and come to speak to us.
Glenn, thank you very much, and I do apologize to everybody for arriving rather late. But I'm glad I was in time to hear my own firm, Allen & Overy, mentioned as a supporter both of PILNet and of Pro Bono Deutschland, as it does support a number of other organizations. I should start by saying that in Britain we have had for many years a system of criminal and civil legal aid which is publicly funded and is provided by several thousand law firms and barristers around the country. The rates of remuneration are not generous and few firms make an appreciable profit on the work, but combined with conditional fee arrangements for personal injury work, the scope of legal aid has really allowed most of the less well-off citizens to obtain legal advice and representation to assert and defend their fundamental rights. And of course, it also created a highly skilled cadre of lawyers working in the fields covered by legal aid. But those assumptions have been challenged by a very recent piece of legislation, the Legal Aid Sentencing and Punishment of Offenders Act, which was passed into law only last month. And a consequence of this law is that in some very important areas like private law, family work, housing, immigration, welfare benefits, vulnerable members of society will find legal advice and representation in the courts funded by legal aid much more difficult to obtain. Now, we, the Law Society, together with the Bar Council, whose chairman Michael Todd is here in the hall, believe that it undermined a fundamental principle in our jurisdiction of ensuring access to justice for all. And we did achieve some notable successes during the progress of the Act through Parliament, but we can't pretend that the final Act is the outcome that we would have hoped for. The reality is there'll be far less civil legal aid available in England and Wales, with major implications for both legal aid practitioners and their clients. And I fear it's unlikely that many existing civil legal aid firms will be able to continue with their present business plans. Some firms will close, others will merge, and most will be looking for alternative income streams. Therefore, the task falls on the Law Society as the solicitors' professional body working to support the rule of law in England and Wales is twofold: to help the profession adapt to the new regime and to do what we can to mitigate the unavoidably negative impacts of the Act on access to justice for the least well-off. So it is a rather important time in the UK to review the scope of pro bono work that may be needed. So we have to go back to first principles and consider what our clients need and whether lawyers are necessary or best placed to meet those needs and how those needs can be funded. And we also want to consider how new technology and the development of alternative business models whereby non-lawyers can own, invest in or manage law firms and form multidisciplinary partnerships, allowing law firms to provide a broader range of services, might open up new ways for solicitors to meet at least part of our clients' needs that are in a way that's accessible and affordable. And that might include considering alternative practice models for the provision of affordable legal services, such as ABS or community interest companies, which are a type of company designed for social enterprises that want to use their profits and assets for the public good. We may be looking at alternative methods of service provision, such as online services or providing fixed-fee advice on specific elements of a case, rather than taking on an entire matter, as well as examining what could be achieved by wider public legal education. And in this changed climate, a new space is clearly created for the provision of pro bono legal work. That's to say, work undertaken by lawyers voluntarily and without payment, or in some cases at a reduced fee. But any talk of pro bono has to be framed in terms of the understanding, which is the basis of everything that we do, that pro bono should only be an adjunct to and not a substitute for a properly funded legal aid system, something that several speakers have already emphasized. But we do recognize, nevertheless, that pro bono is an important element in the provision of access to justice, with a long and venerable tradition that benefits the public and the profession. Specifically, pro bono work is good for solicitors and legal practices because it can develop professional skills and knowledge, build confidence, boost morale, enhance recruitment and staff retention, and win business from clients who expect their suppliers to demonstrate a commitment to society, just as their own organizations typically do, the point that Michael was making just now. More importantly, of course, it helps to make people who'd otherwise go without legal representation able to exercise their vital rights and interests. Now, research undertaken by the Law Society indicates that last year an average of 55 hours of pro bono work per solicitor was undertaken last year, and if one were to value that at normal charge-out rates, it would be worth over £500 million a year, or 2.44% of the entire profession's gross fee income. Now, because we at the Law Society are committed to and believe in the benefit of pro bono work, we have a partnership with and are the principal funders of LawWorks, which is the main pro bono clearinghouse for solicitors. Undertaking pro bono through a clearinghouse enables the solicitors to focus specifically on the provision of legal advice to those who most need it, leaving the management of applications for help and expectations from the client to LawWorks. And having a central coordinating body such as LawWorks with established systems and processes also enables innovative and strategic programs to be developed in addition to emergency responses. And we also support a number of other measures to encourage pro bono work, including providing practicing certificates to unemployed solicitors who wish to do pro bono work in order that they can continue to maintain their skills and confidence and keep close to the profession while they're looking for work or who are on a career break. And we've also seen the proportion of law schools offering pro bono work opportunities to their students increase to more than 2/3 of all law schools in England and Wales. And I had the great privilege to judge the annual competition between law schools for their pro bono work recently, and it was very inspiring work, mainly focused on their local communities. We haven't actually set a target number of pro bono hours for solicitors, though some firms, of course, have done so on their own account. And there are some lawyers who support pro bono work and would like to see the Law Society take such a course, but as I say, we've not done so yet. We also have a very important role as the Law Society in recognising and promoting the pro bono work of solicitors. Pro bono features prominently in our National Law Society Excellence Awards, recognising the pro bono contributions by individuals, firms and organisations every year. We also co-sponsor National Pro Bono Week with the Bar Council and the Chartered Institute of Legal Executives, so that each November there's a sustained campaign of events and communications to recognise and celebrate, and of course increase, the amount of pro bono work done by the profession. But in the new environment created by the Legal Aid Act that I mentioned earlier, we need to do more, and specifically involve more stakeholders, both within the profession and outside, to find new ways of bridging the access to justice gap, which has been created by the cutbacks in legal aid. So starting later this month, we will start convening a series of debates on the theme of protecting access to justice in a post-Legal Aid Act world, bringing together potential funders and voluntary organisations and legal aid lawyers to find the best and most innovative ways of ensuring that the most vulnerable members of our society are not left unprotected and unrepresented. So pro bono should not, as all of us here agree, in a modern, prosperous, democratic society which values the rule of law, be a replacement for a properly funded legal aid system. But there should always be a place for the provision of legal skills and services on a pro bono basis to ensure that all members of that society have recourse to the law should they need it. Thank you.
Before I go over to, let me, as chair, shoot a first question. 55 hours a year, 500 million pounds of free legal services. How do you account for the success? You don't have a rule, even a non-mandatory rule. How do you motivate or encourage the members of the Law Society to dedicate time to pro bono?
Well, Glenn, I'm not sure how much we really need to. It seems as though there's such a philanthropic commitment, or a commitment to society on the part of lawyers taken as a whole, that really suggests that a minimum level is not, given how developed our pro bono market is, really necessary. But I think we have to keep up the momentum and raise the bar, because there are new challenges to meet in new areas where provision has to be made on a free or accessibly priced but not publicly funded basis. So there is a challenge.
Hi, I'm Michael Todd. I'm chairman of the Bar of England and Wales, John's contemporary, so to speak. I think the discussion today has highlighted that when we talk about pro bono, we're talking about very different things, or pro bono means very different things to very many of us. Michael over there was talking about not domestic pro bono. John, I think, was talking about what I would call domestic pro bono because of the absence of legal aid and the inability of people to obtain access to justice. That's certainly where, at the moment, the Bar is focusing most of its energies, because we've just had this Legal Aid Act, as John has said, which has removed whole areas of work away from scope of legal aid, so there's no publicly funded, no public funding available for it. And I must say, at the moment, I think and I think probably Law Works as well, but certainly the Bar Pro Bono unit focuses very much on domestic pro bono work, i.e. giving access to justice to the citizens of our own jurisdiction, Other people, and I think Michael would perhaps agree with this, and I know ANO do quite a lot of work, say, for A4ID, Aid for International Development. And that, in a sense, is another sort of pro bono work, isn't it, which people do. They provide their legal services to developing countries to assist them with a construction project or whatever in a different jurisdiction. And then on the other hand, on the third sort of pro bono that people have been talking about here, it's actually what we would call in the UK legal aid. And I'm really quite interested here in what the panel's views are, where the focus is for you as lawyers. Is it on domestic access to justice, or is it helping people who can't help themselves? It may not be an access to justice issue. It might be helping with a development project in Africa, for example, which some people would see as a pro bono work. So I'd be interested to know how people see it across the board.
First, the way that we see it, well, PILNet's priority is on what you're calling domestic pro bono. Our priority is to try to bring in private sector resources to supplement what government and what civil society are already doing in developing and transitional countries. Cross-border pro bono, what you're calling as international projects, or sometimes we call cross-border, is an important supplement or add-on to that. Sometimes it can even help jumpstart domestic pro bono. But the quantum is really quite low. Well, in our view, in the long run, taking the long-run view, the quantum of cross-border pro bono will never raise to a very significant level in terms of the impact it's having compared to a well-developed domestic pro bono culture. And so that's why that's our priority. But Monique might have something to say on this, too. Yeah.
Jump in, yeah.
Let me then introduce Monique Villa. Monique is the CEO of Trust Law. Trust Law is the pro bono clearing portion of Thomson Reuters, the world's largest information system.
Okay, so thank you very much, Glenn.
Included by us.
Yeah. So I'm the CEO of Thomson Reuters Foundation, which is the charity arm of the big media company that you know. And interestingly, I come from a totally different background from all of you because I'm not a lawyer, I'm not a professor of law, I am a journalist, and after being a journalist, I was managing the business in AFP, Agence France Presse, and then in Reuters Media. So I was the managing director of the news agency Reuters. And when Thomson acquired Reuters, the CEO asked me to take the foundation and transform the Reuters Foundation into something bigger. And one of the big businesses of Thomson is Westlaw, which is a database for many lawyers and judges around the world. So I was looking at what to do in the law area. And this is where I came to discover how great people are the lawyers. And I don't say that to flatter you or anything. It's just that one day I was in Washington meeting a man, a lawyer, who told me he created the Pro Bono Institute in Washington 27 years ago under the principle that all the law firms that would be member of PBI would give minimum the equivalent of 2.5% of their revenue, annual revenue, in 3 hours, which, when you know the American law firm, which are very big, represent a lot of money. So I said, this is extraordinary, and does it work? And he said, yes, it works very well. And more or less, it works very well in 5 countries in the world, which are namely UK, US, Australia, Canada, and South Africa. In the rest of the world, pro bono is completely ad hoc because a lawyer knows an NGO and helps them, or doesn't exist, or even as it was in Germany until a few years ago, it's forbidden. So the idea to create the biggest marketplace for pro bono and spread the practice of pro bono worldwide came to me. And so I created Trust Law. Trust Law was launched 18 months ago, 20 months ago now. It was July 2010. When we launched, we had 180 members, 180, and today, 20 months after, we have 750 members, of which 250 law firms. So 250 law firms is a lot of people. All the ones you mentioned are members. At the start, it was very interesting because the American law firm told me, you know, it's good to spread the practice of pro bono, so fantastic you do that, but, you know, we don't need you because we know how to do it. And last week, DLA Piper took their 29th case on trust law in 1 year. So it just shows that it gave them the opportunity to give to their lawyers who want to work pro bono, as you all explained, a fantastic place where finding interesting cases. So this has grown so fast because there is an enormous need around the world among NGOs and among social enterprise, which are the two categories that we help with trust law, because if you give them a lawyer for free, they can spend their resources on their mission and on what they have to do and not on legal support. So we have grown very fast. We have now 450 NGOs and social enterprise members of trust law, and it's growing by the week. So I was in Russia this week before this forum, where I thank you to have invited me, to meet a lot of social enterprise and NGOs to have also demand in Russia, as we have in China. In China, 3 of the biggest law firms in China are members of trust law already, and we want to develop that in Russia too. So very quickly, in 1 year and a half, 20 months, we have already helped lawyers solving 350 cases on trust law. The first year, law firms calculated that they have spent on trust law $11 million in 3 hours for that, so very high-quality lawyers. And in countries where they never had access before, we are all over Africa, we are even in Papua New Guinea, we are in Afghanistan, we have law firms all over Asia, etc. But what came very quickly through that, because I've traveled the world to meet so many people on both sides, beneficiaries and law firm, and convinced them to be part of trust law, we did some very big programs. And I will just give you a few ideas of programs that we have done, or that we are going, and that help disadvantaged people or minorities to defend their rights. And it also helped to reform the sector of charities and of social enterprise in a number of different countries, because there is many ways where you can reform this sector, which is still emerging and burgeoning. So we do, for social enterprise, for instance, we have now members of trust law, something like 80 fellows of Ashoka who have created social enterprise and were very good around the world. And we help them from very basic things like we do in Brazil, or in very sophisticated programs, as we do for the Schwab Foundation, which is the foundation of the Davos Forum, on the creation of how to improve the world of social investment around the world. We also help, for instance, a very cutting-edge NGO, which is creating the first social stock exchange in Mauritius. So a social stock exchange where big social enterprise will be able to be floated to then have access to more equities. One of the first program we did was at the request of the biggest microcredit organization in Europe, ADI, and they asked us if we could speak to law firms to help them study the situation of microcredit in the 27 countries of the EU. So what you said before is absolutely right. Law firms fought for this program because they love it. So Latham and Watkins and Oric, in that case, fought to get it. Finally worked together with another 19 law firms, because it's 27 countries and they are not everywhere, and produced a very authoritative paper of 150 pages that after that we published in EGAN, in Westlaw. And ADI now does their own advocacy with the Commission in Brussels and with the different governments in the 27 countries of the EU around it. Another one was in Haiti, a grassroots organization 1 year after the earthquake. And as you know, maybe during the earthquake, the number of rapes of women and children was multiplied by 3 because of the conditions of living there. So they asked us if we could organize a program where law firms would study and compare how 6 countries put an end to the impunity against rape. And this is a program that was coordinated by one of the big law firms, but 4 of them participated in it. And it has been distributed to the MPs and the government and the President of the Republic in Haiti, and is now part of the process of law in Haiti. Another one is Transparency International, because trust law is this big tool, big marketplace, but we also cover news, because if you want to spread the practice of pro bono worldwide, better speak of it. So we have a website which is open to the public, where we cover pro bono issues, but where we cover the PILNet Congress, for instance, and other big forums. But also, we cover 2 main issues on this website, which are anti-corruption, because we think that transparency is absolutely key to the development of many countries. And we cover also women's rights, because if you want to tackle at the root of poverty, you help women know their rights and defend their rights, and usually they spend 80% of their salary into the family, so it means children are better fed, better educated, etc. So these are the main issues. And because we have this double effect of having sorted, 350 cases in 1 year, and then speaking of it, and this multiplied the effect very often in countries. It's growing very, very fast. So we started very small, and now I have 2 lawyers in my team, one of them here. She has joined from Baker and McKenzie. This is another example. Lawyers can have a cut in their salary to go and work for a charity like mine, and she did that. Another. Yeah, I know, but she accepted a cut, which is quite remarkable. And it just shows that in the world where we live in, more and more young people are motivated by trying to do things right. And another example is that very big corporations like General Electric or Goldman Sachs or Merck or Vodafone are also members of Trust Law, because they have armies of lawyers around the world, and they want these lawyers to do pro bono, so they have access through trust law to pro bono cases in the country where they are. So, voila, this is what we do.
Thank you very much. Okay, thank you, Monique. Maybe a question or 2 at this point. Certainly an inspirational presentation. Okay, no questions now. I'd like now to introduce our second to last speaker. He's representative of the Ministry of Justice of the People's Republic of China. I can't give you his biography because he's a last-minute addition to our panel, but he is in charge of the Department of Legal Aid within the ministry. So I'd like to turn over the floor to Mr. Wan Yongyi, if I pronounced that right.
Ladies and gentlemen, I'm happy to take part in the International Legal Forum in St. Petersburg. I'm happy to be able to discuss the issues on the agenda. I work in the Ministry of Justice of China, and I would like to talk today about the pro bono in China and about the new challenges really, if we compare pro bono in China and in other countries, we can say that our system is quite young. And it was in the 1990s that it began to develop. And over the past 5-6 years, it has been developing relatively rapidly. In the year 2003, the law was adopted in China on pro bono legal aid. And then not many lawyers were involved in that. But over the past 20 years, the system has been developing. Although we have not been working for that long a period of time, but after 2003, the development accelerated, and our government supports the pro bono services in all fields. Now, concerning the number of pro bono entities and structures in China, we have 3,700 of those, and these are centers, these are different other types of structures, and the Minister of Justice manages their work. As for the number of lawyers, there are 14,000 of them, and some of them are lawyers, professional lawyers, and then there are some paralegal staff members. I spoke just about those entities that were established under the auspices of the Ministry of Justice, but there are other type of entities and institutes established by the public sector, so to speak. And so the number of these has been increasing, and the number of their employees has been growing. In 2011, the local governments and the central administration actually increased the funding to 1,200 million Chinese yuans, and actually there is an annual increase of funding that we're witnessing. In 2011, the number of cases, pro bono cases, went up to over 8,000 cases, and their number has been increasing, and that's by 20-30% annually. And this is happening because the funding by the central government has been increasing. We can say that this system in China has been developing rapidly, and the purpose is to satisfy the needs of the poor people in China. Indeed, China is a densely populated country, and there is a gap, a deep gap between the poor and the rich in the country, and so we come across many challenges, and one of those is the resource for pro bono legal aid. What kind of resources do we have for that? We have human resource problems and financial problems. Let's take Chinese Northwest, relatively poor regions of China. This system is not well developed there at all. So we need to look for different ways of helping the poor people of Northwest China. At present, this region requires various types of assistance, and it's one of the challenges we are dealing with. And then, secondly, we really need to increase the volume of legal aid rendered for our citizens. Now, we need to do quite a lot to improve the quality of this service, and this legal aid should be also rendered timely. That's another important issue. So that is the basic level of work for us, quality and timeliness, and the main requirements were set. Lately, over the past 2 years, this work has been developing very well indeed. Not everything is that easy and simple. That's true. Our purpose is to help first and foremost the poorer, the ones who under regular conditions cannot get any legal aid at all. And third, the quality of legal services, that's another important issue, and then supervision over the quality.
In terms of the quality of assistance that is currently rendered is not very high. The quality of assistance is very important to us, and we talk about the entire scope of legal assistance. We need to improve the quality, and this is the main task for us. How can this system of quality control be created? How can we assess the quality? How can we process the possible claims? These are the issues that we're trying to take care of at present. The fourth point. We have a number of current issues facing us. That includes the improved quality of legal assistance management. And this is directly related to the question whether or not we're able to complete and meet the goals that were formulated for us by our government. We do not have enough funding, though. The big figures that I gave you, if you recalculate them per capita, you will see that the population of China, which is several billion people, you will see that no more than yuan is allocated per person per year. I hope that the situation will improve. We do everything in our power to improve the situation, and that the government pays a lot of attention to this. As you know, perhaps that we are in the process of implementing the five-year plan, and part of this plan is to improve the quality of pro bono services to the population. This includes legal assistance. In the past few years, we have seen challenges but also opportunities, and these challenges and opportunities coexist. But I think we have more opportunities than challenges, and we'll try to do everything in our power to improve the services and to better meet the needs of our population in legal assistance. This is all I wanted to say. Thank you.
I'd like to ask a question. Thank you for the presentation. Am I being translated? Yes. It's on. It's on. Am I being translated? Are you getting translation of my question, Mr. Wang?
Yes.
Okay. So the description of the rapid growth of the legal aid system in China that you gave us is truly impressive. I know about it firsthand myself from having visited, and it's remarkable. From what I understand, the legal aid regulations also require that if the legal aid system assigns a case to a lawyer, they must take it. It's it's a sort of a mandatory, what we would call in the United States, a mandatory pro bono requirement, 1 or 2 cases a year, if the legal aid centers, if the Justice Bureau Legal Aid Center assigns it. That's also an interesting achievement, although I understand it's not implemented everywhere. My question is, do you think there's potential to supplement that kind of legal assistance, which I would call legal aid, with an appeal to private practitioners' social responsibility on a voluntary basis to also contribute to meeting the legal needs of the Chinese society? Is there potential for that in China?
I think you understand how the system works in China very well. Yes, indeed, we have free legal aid in China, and there are certain requirements, statutory requirements. The current legislation on criminal cases, on criminal procedures, and there's a law on lawyers have a number of provisions. But legal services are not for free. So lawyers are not provided for free. There's a subsidy funded by the government. I told you earlier that more than 14,000 lawyers and paralegals work in this sphere. But we have 1,300,000 people in China, so 14,000 is not enough. Obviously, a large number of population is forced to apply to the so-called community lawyers. And even though lawyers are required to take 1 or 2 cases for free per year, the government subsidies are not very high, and they do not help to cover the costs. And lawyers don't want to work for less than they are used to take. So what we can do is to first increase the subsidies, the amount of subsidies. Within the next 5 years, our plan is to increase the amount of subsidies. We know that the problem exists. In order to be able to meet this goal, we need to do, first of all, to increase the amount of subsidies going towards the covering of lawyers' fees. I think the situation is improving. There is still a big gap between the level of subsidies and the subsidy and the cost of legal services, the actual cost. And the difference is between 300 and 500 yuans. There's also a big difference between, for example, the western and central regions of China. It might be enough in the west of China, but it definitely not enough to cover the lawyers' fees in the central part of China.
Final speaker, because I noticed that the audience, which had prior to this moment been building and building, is starting to decrease in size, which indicates, I think, that first of all, people are a little bit tired, and secondly, the room is extremely unpleasant, both acoustically and temperature-wise. So it may have other aesthetic values, but certainly not a practical room. In any case, the final speaker will perhaps forgive me for putting him final, because he's a good friend of mine and colleague. Recently, Dmitry Samogulin and his law firm RBL, which is based in Samara on the Volga River, was awarded the prize or the distinction of being the top pro bono law firm in the regions. I think that's correct, by Legal Insight magazine. And this results from a program that they have conducted, at least in part in connection with PLI-NET. So it's my pleasure to introduce Dmitry Samogulin, the managing partner of RBL Law Firm in Samara.
Thank you. Thank you, dear colleagues. As far as I understand, Glenn decided that I will be served as a dessert. Let me give a very small remark first. The award that Glenn told you about, it wasn't an award given to me personally. It was given to our company, and I am a managing partner of the company. So this is not something that I did. It is the achievement of the entire team. We all worked on a number of different pro bono projects, so I don't want to rest on my laurels. I am not the winner here. I'm just one of the partners in the company, and of course I did contribute to the success of this work. However, in order to follow up the discussion here, in Russia, I think there are three existing viewpoints on the free legal assistance, pro bono, we may say. The first point of view, and many of my colleagues subscribe to it, is that pro bono services should be provided, that pro bono should exist. The second point of view, again, and there are colleagues who side with this point of view, they think that lawyers should not be involved in this kind of work, that philanthropy is not our purview. There are government structures who should be doing that. Lawyers should not be involved in this. And the third point of view are the people who actually are involved in pro bono, but sometimes they mix it up with subsidized assistance. They also often mix it up with free legal assistance that they still get compensation for in the form of other services, or compensations may take other forms. So I think there's a lot of mixing up of pro bono and free legal assistance and legal assistance for a compensation of other kind. One of the facts that show you the situation with pro bono in Russia is the fact that last year at the European Pro Bono Forum, and Glenn mentioned it, did not have a single Russian representative. I think it speaks for itself. Unfortunately, I myself was not a participant in that forum last year, but there were more than 300 people present. They represented the legal community, the lawyers community from all over the world, but there was not a single person representing Russia. It is sad, but it is a fact. At the same time, we have to admit that the situation is improving, slowly but surely. I believe that the principle of social responsibility of the legal professions ceased to be a slogan and has been adopted by a lot of lawyers in Russia. I can give you statistics to prove it. The Pillnet, which is a company that we cooperate with, processed more than 250 applications from non-government organizations. And most of them, if I understood correctly, were processed by various legal entities, legal firms, law firms. The fact that a lot of firms are involved in this work and their number increases every year is very good news. We have faced a number of challenges, however. Since the number of lawyers involved in pro bono increases, we can see that the risks are increasing as well. And there are certain risks associated with pro bono legal practice. First of all, we're talking about civil risks, procedural risks, but at the same time there are tax risks. Now, when we're talking about civil or procedural risks, the fact is that the Russian legislation does not specify what pro bono work is all about. There's no such definition in the Russian legislation, and that means that there's no regulation that would determine and define pro bono. Pro bono, which is providing legal assistance for free, is in fact part of a civil contract. There is no compensation, but the other conditions are all present. Other aspects of a contract are still there. And that means that these contracts are covered by the civil code of the Russian Federation. At the same time, as I said, there is no clear legislation that would regulate this work. Another question arises, whether or not from the point of the Russian legislation pro bono is charity or not. In some cases this may be charity work, in some cases the situation may be reversed, because it does not have to be charity even though it may look like charity. And why is that important? Because that brings us to the risks associated with taxation. The Russian tax legislation does not provide any incentives for pro bono in Russia. If you look at the legislation in detail, you will see that in some cases the party that provides pro bono services, and we're talking about law firms, and the party that receives legal services pro bono, an NGO, may find themselves in a situation when both parties have to pay tax. And that seems quite ironical, but we're talking about pro bono, we're talking about free legal services, and yet when we get to taxation, both parties may be liable for tax. And the government does not scrutinize this area yet, but I think it's the question of time, whether or not they have found any violations there yet. And we should look at this area and try to eliminate the risks. These kind of problems need to be raised, and so far these problems have not yet been resolved. So when pro bono services are provided in Russia, you have to keep in mind that you have to be very careful not to face the risks I mentioned. But I don't want to finish my presentation on this sad note. I would like to say that more and more people are involved in this work, and this is very pleasing. I can see a lot of my colleagues, lawyers, taking on pro bono cases. There are a number of points a number of factors that contributed to the development of pro bono in Russia. The first thing that was mentioned by my colleagues is the improved quality of legal education in Russia. Lots of law students have gone through a legal clinic at the university, and so from the very beginning they were able to imbibe certain standards of the profession. It now seems natural for them to render services to some categories of population for free. I also would like to mention the contribution of the non-governmental organizations who helped the development of pro bono in Russia. I already mentioned PillNet, but also today I met a colleague of mine. I don't know if you work in Russia. Do you have a representative office or some kind of an office in Russia?
We don't have offices. We have a person from the foundation, but we don't have offices all over the world. We are global, but not sitting in every country.
But if our colleagues decide to open an office in Russia, for instance, that may be another step to involve more lawyers, more representatives of the legal profession in Russia to this sphere. Thank you for your attention.
That occurs to me is that if you look back at the history of Russia, a very young history in the post-Soviet period, the first decade or so of the post-Soviet period, the legal industry was establishing itself in Russia, and lawyers were really working out a way to earn a living. And I think that now that there are many, many successful Russian law firms, both in Moscow and St. Petersburg as well as in the regions, it's the time that lawyers have started to think about giving something back to the society and making a contribution to rule of law and equality and justice in the country. So this indeed is a very positive factor, and one that I think all of us have recognized. I was thinking that perhaps, Michael, you might be able to touch on how Germany handles the issues that Dimitris mentioned with respect to taxation. Is there an issue of VAT and profits tax for the recipient of VAT for the provider and profits tax for the recipient of legal services?
Actually, I don't know for sure, because what we're doing as pro bono work by Pro Bono Deutschland and the large international law firms operating is really providing free legal assistance to non-profit and non-governmental organizations, often on corporate and tax issues, to individuals where there are, sometimes human rights issues, but really generally restricted to cases where there is no market for paid legal services. So we don't engage in legal aid. So I'm speaking about something I don't really know from my practice, but as far as I understand it, legal aid is really a lawyer providing the legal service being paid by the state, and I would assume that this shouldn't include VAT, because it doesn't make...
Just like we record hours for Gazprom Bank or Societe Generale or what have you. And in theory, I don't think it's happened yet, but in theory, under Russian law, the provider of a service has to pay VAT, even if the service is not compensated. And similarly, if a service is provided to a third person, then that person has received the benefit. And if the benefit is not paid for, in theory, the person has received a taxable gain. So I'm wondering, in the not in the legal aid context, but in the context
I understand. This is an excellent question, and this is probably the best example you can provide for the statement why we're operating in a gray area that's not regulated yet. I mean, we at Deckard, we actually use the engagement letters from the US, we adjust them to German law, but we don't charge VAT. And no one has really finally looked into that and analyzed whether this is right or wrong. I mean, we always report to the local bar association what we do in that respect, and they've seen our engagement letters, and we've never gotten any comment. But this is a proof we're unregulated in that respect, and it needs to be answered. The question, is it yes or no? Right now it is just silence.
Yeah, that issue has been raised in Hungary and Poland, and became subject of great debate, and was resolved favorably so that value-added tax isn't considered to be chargeable to pro bono. But it's not clear. It's still unclear, because it's not clear. Value-added tax is controlled by EU law, and it's not clear with precision what EU law is. So we've actually started a project to try to look at multiple jurisdictions across Europe and at EU legislation to try to clarify, or if not clarify in a positive way, this question, and if it's negative for pro bono, then to change the rules.
When you say in Poland and Hungary the issue has been addressed favorably, it's been addressed legislatively?
No, not legislation, through the bar.
Through the bar, right.
Yeah.
John?
Could I raise a slightly different point? We've been speaking so far as if pro bono can be done only by lawyers in private practice, but certainly in my jurisdiction about 25% of the profession work in-house, and there are similarly high proportions in many other jurisdictions. The desire to contribute to pro bono and CSR on the part of in-house lawyers is no less than it is in private practice. And we've certainly been working as a professional body with the in-house constituency to try and involve people more. Of course, often it works quite well as a partnership between the lawyers in a client and the lawyers in a firm working together on a project, which can again be quite a good client loyalty building strategy, quite apart from the benefits it achieves. Unfortunately, in our jurisdiction, the consequence of our most recent piece of substantial regulation meant that in-house lawyers weren't generally in a position to do pro bono work in areas like representation in court, even if they had rights of audience, because they didn't have the professional indemnity insurance that was necessary to permit them to carry out that activity. So the scope of their activities has been inadvertently reduced, and we are trying to work with the regulators to get that situation turned around again.
Any questions or further comments from the panel? Please, if you could, microphone, and if you could please let us know who you are and what organization.
我是中国代表团的一个成员。
I'm a member of the Chinese delegation, and here is my question. Today, among the speakers, there were two representatives of Russia. So my question is, actually I have two questions to them. In 2011, Russia adopted a new law, and I would like to know more about its content. So the first two laws concerning legal aid and advocacy. So I would like to know more about these two laws.
Я думаю, что, наверное, стоит содержание этих законов обсудить в каком-то отдельном разговоре. И изменения законодательства об адвокатуре я, конечно, не стала бы обсуждать, я не являюсь специалистом в этой области. А закон о бесплатной юридической помощи я могла бы изложить вам и в основном, и в подробностях, но, может быть, нам переводчики помогут в отдельном разговоре. Я это с удовольствием сделаю. Это очень длинный и очень специальный разговор.
Я соглашусь с коллегой, что
Agree with the colleague. Indeed, the question and the answer cannot be given in just a couple of words. You're right, we have two laws. One is on advocacy, stipulates certain provisions associated with legal aid, and then a special law was adopted, as we have already mentioned. But indeed, these are topics for discussion, and this discussion should be a separate discussion. It's really very difficult to give you a short answer to your question. So if you are interested enough, we could talk outside the framework of our roundtable discussion. And Glenn, as a continuation of our roundtable discussion, I would like to invite everybody present here to Samara, where at the end of June there will be the Volga Region Legal Forum, and we will discuss pro bono and free legal aid, and there will be lawyers present at the sessions there, and we will discuss the laws that you have just mentioned. So you are invited.
The Russian law is essentially a legal aid law, as Edwin has mentioned, and I've spoken to a number of people over the course of yesterday and today, and I think the key thing is, as Yelena mentioned earlier, that this law is a major step forward. But since it is a very new law, it's been rather difficult, as I understand it, to obtain the subsidies, and the process of obtaining compensation for legal aid assistance is just really starting now. It also sounded somewhat similar to the Chinese law, although perhaps at an earlier stage. So one can hope that it will develop over the coming years to be something along the line of the Chinese system, while at the same time I agree with Elena and with Dimitri that it's not a good idea to take on too many cases because the most important thing is to maintain an extremely high level of quality of services.
Можно маленькую ремарку?
A short remark, if I may. In the support of what Glenn says, indeed, the legislation of many countries concerning free legal aid talks about subsidized legal aid, which is quite similar by nature, so to speak. But all these laws stipulate that the state provides legal help to the needy groups of population. And this work is compensated. So in this sense, the laws of different countries are alike. But then we come across details which are probably not that significant at all. How are you? Head of the Chief Administration of the Ministry of Justice for the Siberian Federal District, Mr. Stepanov. Now, back to taxes, because it seems to me that we are actually talking about the situation in somewhat aggravated form, because I do not really see any taxes that Dmitry talks about here. If we talk about the profit tax, then there is no profit at all. If it's VAT, then it's an indirect tax, and it is paid, but not by the individual who renders services, but by the individual who receives the service, and he receives the service free of charge. So I think that's not a matter for discussion indeed. I don't think there is a problem with that in Russia at all. Thank you. No, I might disagree with you, but since I'm a consultant on taxes, and but I do think we should have this discussion outside the framework of our roundtable. I will talk to you. I will explain to you why I have this particular viewpoint and why I focused in my presentation on these principles. We're not saying that the the tax authorities are trying to collect these taxes. No. This has not happened, and probably will not happen. But nonetheless, if there is a risk of that, then this risk should be dealt with through legislation. Microphone. Now, we need to recognize that you are right in one aspect. We definitely are not saying that in any case pro bono leads to the need to pay taxes. Glenn has given us an example of a specific situation, but the most widely spread when a law firm, and we know what the specifics of the legal business are. Most of the law firms different types of shareholder and stock companies, and they have certain strict provisions with the profit tax and VAT. And when they provide services to non-commercial organizations, only then the issue of VAT and the profit tax rises. And I can assure you that there are tax consequences indeed. And considering this particular aspect, the legislation actually stipulates that we can optimize taxation if in the contract we specifically indicate that it's charity work. In this case, we talk about the tax benefits, and if the contract does not contain this particular provision, then you are under the general rule of taxation. Now, I think we should really discuss this topic in more detail, but it's one other matter. You are generalizing things here. We should apply the tax law to specific cases, so I suggest that we, move over to a different topic. Glenn, still a short remark. Another short remark. Why is there is such a lively discussion? I suppose that simply proves that this is a topical issue. You can see the discussion is there. That means there is an interest.
Any other questions, comments?
Yes.
Please.
So please do come to Samara for the next discussion. But also, please come to Madrid if you're interested in continuing this discussion about pro bono in a comparative context. Our European Pro Bono Forum is held every year. This year in Madrid, October 25th and 26th, and you can find information here. Thank you.
And as far as the seminar in Samara, you can find information about it on the site of legalstudies.ru, legalstudies.ru, and I encourage everyone to go to that event as well. I certainly will be there. It may not be as sexy as Madrid, but it is on the Volga, so it should be interested in that respect as well. All right. Any other questions, comments, thoughts? Okay, in that case, I'd like to thank a lot of people. First of all, I'd like to thank the Ministry of Justice of the Russian Federation for granting my suggestion of holding this roundtable. It was supported very strongly by Minister Konovalova, and apparently even the Prime Minister supported our topic. As you know, he was the president when the law came into effect. So, secondly, I'd like to thank all of our panelists. Many of them, other than Yelena and myself, had to come from quite far away. And I think we have a very diverse panel representing different countries, different legal cultures, etc. And finally, most importantly, I'd like to thank all of you for coming. I personally believe this is an extremely important topic, one that will become more and more active over the next several years. And I'd like to thank you all for participating, for asking questions, and to urge you to continue to discuss these issues with the panelists, among yourselves. Feel free to call or write to me at any time. I think my address is available in the materials, but if not, please come up to me and I'm happy to give you a card. And I think all of the panelists feel the same way. This is not, this is something that we're excited about, we feel is important, and we're quite anxious to discuss it with any and all of you. So thank you very much for coming.